Hello and welcome to EntryPoint, where we take a deep dive into the latest entries from Encyclopedia Virginia with the contributors who wrote them for us. I'm Patti Miller, the managing editor of Encyclopedia Virginia, and I'm thrilled to be hosting today's EntryPoint about Virginia and the founding documents. For those of you who aren't familiar with Encyclopedia Virginia, we are the free, online, reliable multimedia resource about Virginia culture and history from the University of Virginia and Virginia Humanities. You can see all the entries we'll be discussing today and all of our entries at encyclopediavirginia.org. A couple of housekeeping notes. We will have time for questions from our presenters today, so please use the Q&A feature to put your questions in the chat, and we will get to those once we hear from our presenters today. We're going to jump right into it. I'm pleased to introduce our first presenter. Steve Sarson is the author of our new entry on the Declaration of Independence, and he is the author of The Course of Human Events, History and Consciousness in the U.S. Declaration of Independence. So, Steve, please tell us about the U.S. Declaration of Independence and maybe some perspectives on it that some people have not thought of.
Okay, well, thank you very much for having me here. It's a delight to be here, and I hope we have lots of interesting questions. I'm sure we will. So, are the slides
We have
available?
slides. I'm going to put those
Okay, if we
now.
go to slide two,
Okay, hold on
that
one
would be
second.
great.
Or everyone's windows are being a little stubborn today. There we go.
Okay.
All right.
Okay, so I'll trust you to move the slides on as I indicate, if possible.
Okay.
Okay,
Hold on
great.
one
Thank you very
second.
much.
Let's just
Beg your pardon.
share. There we go.
All right.
Technology is both our
Yeah,
friend and our enemy. Okay,
it
and now we're
is.
just going to play this. Okay, and here we go.
Okay, so there we have the famous John Trumbull picture that hangs in the Capitol. Always, we've seen a lot of that in the last few days. And there's what are often called the first words of the Declaration of Independence. They're certainly the defining words as we understand the Declaration. We hold these truths to be self-evident that all men are created equal, endowed by their Creator with certain unalienable rights, life, liberty, and the pursuit of happiness. And these are the defining words of the Declaration, or have become the defining words of the Declaration, as used by abolitionists, civil rights leaders, notably Martin Luther King, women's rights activists, and many others. Yet they've also left us wondering many things about the original authors, the founders themselves. Why would they articulate such grand principles before then getting into the nitty-gritty and even grubby grievances? There seems to be a disconnect between them, according to our sense of the Declaration. And secondly, if they believed in equality and natural rights for all men, then why did they practice inequalities? Were they hypocrites? Were they visionaries for the future? How could they tolerate either way the inequalities of women, and most notably, of course, in slavery itself and enslaved people? Now, I think the answer lies here. Thank you for moving it on. In what are actually the first words of the Declaration. In particular, two phrases: the course of human events and the laws of nature and of nature's God. And these words, I think, really frame the rest of the Declaration. And we can understand both the Declaration's call on natural rights, because natural law gave people natural rights, but it also allowed people in certain circumstances, historical circumstances, to abrogate people's natural rights. And it did not mean that all people are equal in every way, just in certain ways. So that's what I'm going to talk about today. How the Declaration, what it really meant by its course of human events and its laws of nature. Nature's got a bigger thing than just natural rights. So if we can move on to the next slide. So here we have some quotes from John Locke and his famous two treatises of government. And you can see there that Locke perceived the laws of nature as working in history. And he really did believe that this was history, not just abstract theory. So the state of nature has a law to govern it which applies to everyone, that all being equal and independent, no one ought to harm another in their life, health, liberty, possessions. But of course, some people do, so people move into society and have government and laws to protect themselves. But then the obligations of the laws of nature cease not in society, but are drawn closer and by human laws, not humane, but human, have penalties to enforce their observation. And so the law of nature stands as an eternal rule to all men, legislators as well as others, and princes owe subjection to the laws of God and nature. So, how does all that work, historically speaking, in the Declaration of Independence? How do these laws of nature and nature's God define what the Declaration says? So, if we go to the next slide, we can see we hold these truths to be self-evident. All men are created equal, endowed by their Creator with certain unalienable rights, is a historical claim about creation and the state of nature. It's not about the future. It's not an abstract principle to be put in the future. And again, we can see that if we look at John Locke, whose first treatise argued against Robert Filmer. Robert Filmer argued for um, that Adam had been given by God, by divine right, absolute power over everyone and absolute ownership of everything. And you can see here that Locke's purpose is to argue that God gave no power to Adam over anyone and gave the earth to everyone for the sake of their survival, the natural right to life. And so, what all men are created equal really means is that in a state of nature, everyone is individually self-sovereign and everyone has access to the earth. It doesn't mean more than that. That's enough, but it doesn't mean that all people are equal, which is a point I'll come back to later. So let's have a look at the next slide, and there we are. So what does this mean for the origins of government? Well, of course, in a state of nature, there's no supervising authority to make everyone safe, so people join. Equality means that people must consent to be governed, everyone, or they can leave a jurisdiction, pursue their happiness elsewhere. And everyone has an equal right to protection of their life, liberty, pursuit of happiness, their unalienable rights. And you can see as well there that this is indeed historical. The Declaration itself says governments are instituted among men, not will be, should be in the future United States, but are. Present tense, but indicating past practice. And again, a few quotes from Locke. This consent was the beginning to any lawful government in the world and the practice of the world from the beginning to this day. And I've given several examples out of history and so forth. So it's all historical again. So if we then move on, there's another element of qualified equality in the right to revolution. The government goes on. Whenever any form of government becomes destructive of these ends, it's the right of the people to alter or abolish it. So here we have a statement about popular sovereignty, but it also says the right of the people. So people collectively have a right. People have given up their individual self-sovereignty. You can't do whatever you want. You have to obey the laws as long as they're good. But if they're not good, then your right to revolution is collective. It can't be individual. And also we can see that it's qualified. Prudence would dictate you can't have a revolution for light and transient causes, and people will suffer. But when a long train of abuses and usurpations pursuing the same object evinces a design, it is there to throw off government, to reduce them under absolute despotism. It's the right and duty to throw off such government. And then it kind of siegs in the very similar language and stages of history, all experience has shown. Such has been the patient sufferance of these colonies, such is now the necessity which constrains them to alter their former history of government. And the history of the present king is a history of repeated injuries, usurpations, having in direct object the establishment of an absolute tyranny. So, people have a right to revolution, and that siegs into the grievances, which are based on the laws of nature, nature's God. There's no real disconnect. They are very connected. And if we look at the first set of grievances, grievances 1 to 13, plus the 9 that begin with 4, which are on the next page, if we can turn to that. All of these grievances concern people's, I can't go through them individually, but if people have questions at the end, I'll be happy to give examples. But let's look at the structure of the grievances. So these first 13, plus the 9 beginning with 4, are all about violations of people's um, rights to liberty and the pursuit of happiness. Okay, so then we go on to the final 5 grievances. Yep, these concern the right to life. They're about the war. They're about the king abdicating the protection of his people in the colonies and making war against them. This, according to the laws of nature and nature's good, is not quite enough for revolution. If we can go to the next slide, it says in the preamble of the Declaration, when a long train of abuses, usurpations pursuing the same object evinces a design. And it says in the next bit that the history of the King of Great Britain's, his injuries and usurpations, all have indirect object. Well, how do you prove that? This intention. Well, then we go to the conclusions of the Declaration, which it says, in every stage of these oppressions, we've petitioned for redress. Our petitions have been answered only by repeated injury. So we've told the king he's oppressing us. He's ignored that and continued to oppress us. So that proves the direct object, the design to impose absolute tyranny. And so there we have it, the natural rights, natural law justification for revolution. And the grievances are violations of life, liberty, the pursuit of happiness, and they prove a design, as the preamble says. So where does that leave us with equality? The Americans have had a revolution in the name of these equal rights and life, liberty, the pursuit of happiness, but yet they did not practice it. So how does the course of human events and the laws of nature and God help us understand that? Well, first, back to that first sentence again. It says, when in the course of human events it becomes necessary for one people to dissolve the political bands that have connected them with another. So the Declaration is really about one people, not all men. All men is a historical condition of the state of nature, but when people create a government, consent to be governed, they become one people. How was that one people created in America? Well, the conclusion refers to the circumstances of our immigration and settlement here, right after the petitioning of the king bid. And Jefferson expanded on that in his draft declaration. He explained those circumstances. It was a bit controversial, so they dumped it, but it refers nonetheless to the circumstance of our immigration settlement here. And Jefferson expanded, this is a bit Virginian, Jefferson expanded on this in his draft of the Declaration and in his summary view of the rights of British America. And Richard Bland wrote about, another Virginian, wrote about it in his pamphlet, Inquiry into the Rights of the British Colonies, as long ago as 1766. And here the colonists obtained their rights, but they also became peoples. 13 peoples originally, but eventually one people with the Articles of Association of the First Continental Congress and then the Declaration itself, and ultimately with the Constitution. But who was not among those one people? If we can move on. Okay, so one other thing that those circumstances involved was the taking of Native American people's lands. So obviously Native American people were not among the one people created by these circumstances. And in fact, they were enemies because they resisted taking lands that were a wilderness, according to the colonists' concept of the word. And of course, then there were enslaved people. As Jefferson made clear in his draft declaration, enslaved people were not part of those circumstances of our immigration settlement here. So instead, these people became enemies. Slavery was, according to the law of nations, nature, and God, a state of war. And Native Americans were at war with the American people. And that was exacerbated in the War of Independence when the king excited domestic insurrections amongst us. And of course, and brought on the so-called merciless Indian savages. So this fits into the Declaration's concept of the wider laws of nature and nature's God that allowed you in self-defense to kill even enemies in war. In peace, friends, but enemies in war. And then there's one, but what about the people who were in this society? Locke said it again, though I have said that all men by nature are equal, I cannot be supposed to understand all sorts of equality. And Locke there goes on to give examples of some people being more competent than others. And of course, the founders believed that. They said so about women and about poor men who were dependent either by nature in the case of women or circumstantially because they had no economic independence, so they shouldn't be allowed to vote, poor men, including white poor men, not just black men. And so all men are created equal in the sense of sovereignty, self-sovereignty in the state of nature, a right to the products of the earth, a right to consent to government, doesn't mean they actually are equal. And so although everyone's entitled to their unalienable rights, they're not necessarily entitled to other rights. And I'll stop there and allow my esteemed colleagues to say their bit, unless you want to ask something, Patti.
Let me ask you, Stephen, thank you so much for
Sure.
that. It's interesting. Jefferson wrote later in life in 1825, I believe, to Arthur Lee or Richard Lee, one of the Lees, that he was not in the Declaration looking to create a new ideas, that he was
Hmm.
looking to bring forth what was common sense and the common thought, political thought of elite Virginians and elite colonists, obviously. But
Yes.
he wasn't trying to create, it sounds like new rights, he was saying. He wasn't trying to create
Hmm.
something new. Can you just kind of explain that a little bit, what he meant by that, where I'm just expressing the views of the people as they exist right now?
I think he was telling the perfect truth. That was to Henry Lee, who'd written to
Yeah,
him and
yeah.
asked him about the Declaration of Independence. And yeah, I mean, Jefferson was exactly right. And he said, I kind of express the views of the Aristotle, Cicero, and Locke and Sidney and others who talked about the laws of nature and nature's God, and especially in Locke's case, natural rights. And so, yes, he was, on all the other books of public rights, which I take to mean revolutionary pamphlets, and they'd all written about these things. These ideas, they go back. I mean, I mentioned Locke because I didn't have much time, so I wanted to talk about the philosopher who was closest to the Declaration of Independence. But it goes back to Cicero and Aristotle, sort of in the century or so before Christ. So these ideas really were old. And it kind of confuses us about the Declaration because we want to think of these as new ideas or the new implementation of ideas. But the ideas were old, and the ideas of the laws of nature and nature's God, they're natural rights and natural laws, after all. They must have been created at creation itself. So they go back to the beginning of time.
And then
And I
is it
think,
for, especially for Americans, that is a very different way to look at the Declaration of Independence, is not as this brand new thing that burst on the scene.
right. Well, I think we're sort of in two minds about that. Well, Americans are, and many British people too, and others around the world. We think, well, if the ideas weren't new, this was the first time they'd ever been implemented. But of course, that can't be true because those laws had always existed. And also, as Locke said, you know, these go back to creation when Adam was not given absolute power and absolute ownership. Everyone was equal and free. And and it was in a state of nature. And he argued that all legitimate governments since before history, before recorded history, was founded on the principles of consent and to protect people's unalienable rights. Whether that's actually true or not is another matter, but that's what Locke said, that's what the founders believed, and that's what they wrote into the Declaration of Independence, a history of humankind.
Thank you, Steve. And I'm going to
Thank you.
drop a link to your entry on the Declaration of Independence in the chat so everyone can kind of dig into that a little bit more because it's really fascinating. And we're just really scratching the surface here. So next, we're going to turn to Elijah Gould, who is the author of Among the Powers of the Earth, the American Revolution and the Making of the New World Empire, and the forthcoming Peace and Independence, the Turbulent History of the United States' Founding Treaty. And he is also the author of our new entry on Virginia and the Treaty of Paris. And I'm going to put that in the chat too, so you can peruse that at your leisure. Also, another fascinating entry. So let's learn something about the Treaty of Paris, which is not what we usually think of as a founding document, is it?
No, it's not. So, Patty, I also have a short presentation. If I put that into slideshow? How do I get this up onto the screen?
If you put it on your screen, you can just hit screen share and you should be able to screen it. You should be able to share it.
Okay. So if I hit screen share,
Yes, and you should be allowed to do it.
okay,
Make
where
sure
where do I all right, I'm gonna have to find that.
it should be in the bot. It's on kind of in the middle of the bottom panel. It says share, and there's a little arrow point.
Oh, there we
There we
go.
go.
Perfect. Okay. Yeah. All right. I am now
Hit that. See, there
sharing
we go.
and okay, and I'm going to put this into a
And it needs to be
slideshow.
on your screen, right? There you go. And if you hit your play mode, that'll play forward.
Okay. So you can see it, right?
We can see it. And if you go into this slide, there we go. Perfect.
Okay, perfect. All right. So, well, thank you. And Steve's presentation really sets up what I want to talk about beautifully. Steve and I have known each other since we were in graduate school at Johns Hopkins, so we go way back. Yeah, so I'd say the Declaration. If you ask the American on the street, what's our founding document, I think most people would say the Declaration. They might then go to the Constitution. The missing link in that is the Treaty of Paris. And independence was actually a tripod or a three-legged stool. There needed to be a Declaration of Independence. There also needed to be a charter of government. That's the Constitution. And before we had the Constitution, we had the Articles of Confederation. So Congress took care of both of those. They started the Articles in 1776. They're adopted in 1777. But the crucial third step was Britain had to recognize American independence. And until George III recognized the former colonies as independent states, they were still legally under international law colonies in rebellion against their prince. I mean, that's not how Americans saw it, but the Treaty of Paris, where George III recognized the Americans as independent, was crucial. So that's what I want to talk about today. And the peace treaty, the Treaty of Paris, typical for 18th century treaties, was negotiated in two stages. The first, there was a preliminary or provisional treaty, which was signed, as you see on my screen here, on November 30th, 1782, St. Andrew's Day, as the British commissioners, a Scottish secretary, Caleb Whitford, wanted to make sure everyone knew. And what we see here is a painting of the provisional American commissioners, John Jay on my left, hopefully yours too, John Jay, Henry Lawrence, in the middle, Benjamin Franklin, John Adams standing, and then Benjamin Franklin's grandson, William Temple Franklin, who was the American Commission's secretary. Not shown because he was blind in one eye, very self-conscious about his looks, was the British Peace Commissioner, Richard Oswald. Caleb Whitford's also not shown. So this was a painting done by Benjamin West. Sometimes the unfinished character is taken to be as a sign of British ambivalence about the peace treaty. In fact, it was Oswald's self-consciousness about his looks. Anyway, this is the provisional treaty. The treaty didn't actually become official until the definitive version was signed, which happened on September 3rd, also in Paris, 1783. But anyway, so the provisional and definitive versions it's important that there are two versions. In fact, though, the provisional treaty and the definitive treaty were basically identical. So when we talk about the Treaty of Paris, there are two versions, but they're not really all that different. So anyway, So I think one of the reasons why Americans don't talk about this as one of our founding documents is that it's the one founding document that Americans didn't solely author. Instead, it was it was jointly authored and had to be negotiated between the American commissioners, which you see here in Paris, and Richard Oswald, the British commissioner. So it was a jointly authored document, and that reminds us that independence was it was a negotiated condition. It's one thing to declare yourself independent, but you actually, if you are the colony of another power, you need the consent of the old, the former ruler of Britain before you actually are independent, and that's important. And where we see the consequences of that is in the conditions that or what the Treaty of Paris actually achieved. And I'm going to go through these fairly quickly here. First, in Article 1, George III recognized the independence of the former colonies. And in Article 1, it names each of the 13 colonies, starting with New Hampshire, where I live, all the way down to Georgia. Maine, of course, was also part of this, but in 1783, Maine was still part of Massachusetts. It was the Eastern District. So they started with New Hampshire, then Massachusetts, Connecticut, Rhode Island, all the way down. Virginia's in there, all the way to Georgia. And so that's the first article. Some people have claimed that the Treaty of Paris only recognized the states individually. That, in fact, is not true. The other 9 articles recognize the United States as a collective union of states. The Article 2 set the boundaries of the United States. Britain ceded the eastern third of North America, east of Nova Scotia, south of Quebec and the Great Lakes, and north of the Floridas. And so Article 2 set the borders of the new United States, and that was a collective cession. There's no mention of the individual states, no mention that Virginia claimed all of what is today the Northwest Territory. That's not in the Treaty of Paris. Instead, the cession is to the Union as a whole. The Mississippi, and this is very important for Virginia, remained open to the British subjects and American citizens. That's in Article 8. Part of the final peace settlement in the Anglo-Spanish treaty, Britain ceded East and West Florida to Spain. So Florida, which of course today is part of the United States, East Florida and Alabama, Mississippi, and Louisiana, those were ceded to Spain as part of the peace treaty. One of the important omissions in this treaty is there is no mention of Native Americans, and that's very important. And I'm happy to talk about that in the question and answer if people want. That's a very important part of this. There's no mention of Indians in the treaty. In Article 7, Britain promised not to, quote, carry off Negroes and other property of the Americans when it evacuated its remaining posts. And this was inserted at the insistence of Henry Lawrence, who was from South Carolina, but this became a very important part of the treaty for Virginians, where a lot of the African Americans who left with the British in defiance of the treaty were from. And then another really important part of the treaty is that Congress agreed to, quote, earnestly recommend that the American states compensate loyalists who had lost property during the Revolutionary War. And this happened in all the states, certainly in Virginia. but Congress only earnestly recommended. So that was up to the individual states to decide whether they would do that or not. And this becomes another bone of contention because most states did not. I'll talk a little bit in a minute about some of the controversies. The final provision, and this matters hugely to Virginia, is that pre-war debts had to be repaid in pounds sterling. And we estimate that there are about 5 million pounds owed by Americans to British creditors at the end of the war. About half of them are owed by Virginians. And Virginians initially refused to do that. So there are all sorts of controversies built into this. And the big takeaway point is George III, recognized American independence, but that recognition came with strings attached. And to get a sense of how that worked, I'm going to show my final slide here. This is the map. It's actually drawn by a Virginia cartographer named John Mitchell. It was drawn in 1755. Mitchell was dead by the time the peace treaty was negotiated. But the Mitchell map was the kind of map of record that all of the peace commissions used. The French and Spanish actually used Mitchell's map too. And what we see in this map are the borders drawn in red that Richard Oswald and the American peace commissioners agreed to. And these are the maps in Article 2, but this becomes a bone of contention because even though in Article 2, Britain had agreed that it would withdraw from all of this territory, and it would do so, without carrying away African Americans who had won their freedom. In fact, the British, when they withdrew, carried off about 8,000 African Americans who had been enslaved by patriot masters. Many of them, in fact, had self-emancipated. They had won their freedom by fighting for the British, and their Virginia enslavers were furious about that. It was a violation of the treaty. Virginia responded by refusing to repay their debts to British creditors, and they're about 2 million pounds that the British owe. That's 2 million pounds in 1783 dollars. The other thing that Britain refused to do was to actually evacuate a number of forts that were in American territory. The two most important were Fort Niagara in what is today upstate New York, and Fort Detroit in the Northwest Territory, which when the treaty negotiated was still in Virginia territory. And so part of the controversy over the peace treaty involved this standoff over, Britain's violations versus American violations. And this becomes a major bone of contention in relations between Britain and the United States in the 1780s and, in fact, into the 1790s. So Treaty of Paris, enormously important. It's where the United States actually achieves its independence, but it comes with conditions on each side that neither side was really willing to live up to. So I'll leave things there. You may have questions. Patti, you probably do.
I do. And if you hit your stop sharing button, that'll pull that
That'll
down.
bring me back
That'll bring you back
into
into the world of Zoom.
yeah.
So question here, and this will set up Linda's talk as well. How did this really show, how did these various controversies and weaknesses, how did that end up really reflecting on the weaknesses of the Articles of Confederation?
Yeah, that's the great question. And I do talk about that in my article in your encyclopedia. So as I said, This is a treaty. It's not a treaty between Britain and the individual states. And again, you will hear people say, oh, the Treaty of Paris only recognizes the independence of the individual states. Not true. In fact, it is a treaty between Britain and Congress. The problem is Congress is unable to compel the states to live up to that. So a lot of the tensions during under the Articles of Confederation grow out of the state's failure to live up to the obligations that Congress had agreed to in the Constitution. And it's one of the driving forces in the move to initially revise the Articles of Confederation. And in Philadelphia, of course, the Constitutional Convention will decide to do away with the articles and start all over. And I don't want to get in the way of the next presentation, but Article 6 of the Constitution makes treaties the law of the land. And the treaty they're thinking of is the Treaty of Paris. So the peace treaty really sets up the drive for the Constitution. It's not the only reason, but it's an important part of it.
Well, and that is the perfect segue into our final, but certainly not least of our founding documents. I'm pleased to introduce Linda Monk, who is the author of The Words We Live By, Your Annotated Guide to the Constitution, and the Bill of Rights, A User's Guide. And she is the author of both of our entries on the U.S. Constitution and the Bill of Rights that I will drop into the chat. And so, Linda, if you will unmute yourself, you can tell us about the Constitution as the kind of roundup of our run through the founding documents here.
Well, thank you. And thank you, Lige, for your setup. I'm delighted to discover another Lige. That was my great grandfather's name. So happy to be.
No kidding. Where was he from?
I sent you an email about it. He's from Mississippi. So
okay.
you and I can talk more about that.
Mine's from Kentucky.
Well, hello. There you go. There you go. And a lot of my ancestors originally came from North Carolina. So North Carolina, Kentucky, there you go. Well, let's start. Speaking of how Lige perfectly set me up, with a wonderful quote from George Washington that perfectly illustrates the point that Lige made. In 1786, he writes to John Jay and says, if you tell the legislatures, meaning the state legislatures, they have violated the Treaty of Peace with Great Britain and invaded the prerogatives of the Confederacy, they will laugh in your face. I love that quote. I just didn't think of that as a typical Washington phrase, they will laugh in your face. Let's go to the next slide and see the consequences of that. In that same letter, he says, what a triumph for the advocates of despotism to find that we are incapable of governing ourselves. And that's the situation. The Articles of Confederation, our first constitution, are in effect, but essentially inoperable in the sense of anything particularly related to taxes or other concerns are essentially requests to the states. The central government, it's not really a central government, it's a confederation. It has very few powers, and it always relies on the cooperation of the states. So the problems with the Treaty of Paris, and then we're going to the road to Philadelphia. I'm going to set up the other instances. There's also the situation of unpaid veterans of the Revolutionary War. And you may remember from one of the provisions of the Treaty of Treaty of Paris is to repay the war debts and in pound sterling. Well, the merchants of Boston are having trouble with their trade agreements for that very reason. They want to increase taxes, or want the state of Massachusetts to increase taxes. That burdens the Western farmers, who are cash poor economies, and also were definitely affected negatively during the war, because many of them had essentially semi-worthless paper script. and that was worthless because of the issues about, coining money and essentially taxing to be able to have those funds. So in Western Massachusetts, an uprising called Shays Rebellion essentially seized the courts to keep the farms from being foreclosed. The Massachusetts militia refused to go out against their fellow citizens. And so the governor of Massachusetts, with the support of the Boston merchants, had to raise their own army to go and suppress the one might say uprising, another might say democracy extended in Western Massachusetts. In any event, it caught the attention of who would go on to be the framers of the Constitution. There had already been some preliminary meetings at Mount Vernon and Annapolis to call for reform. And in February of 1787, the Confederation Congress did vote to call a convention to amend the Articles of Confederation. That convention met in Philadelphia in May of 1787. Initially, there were 55 delegates from 12 states, not including Rhode Island. And fortunately, the Virginia delegates arrived early, so they developed something called the Virginia Plan that we'll discuss a little bit more. But just make sure about the road to Philadelphia that there were already pressures, which Lies has described, that were inherent. How can you be an independent country if you can't respect the terms of a treaty? How can you be a nation if you can't coordinate the actions of its parts? And so out of that, my personal favorite founder, James Madison, did a lot of, I'm getting ahead of my slides, which is not uncommon. Let's go ahead to that second slide. Okay, the point is that this Constitution that's going to come out of Philadelphia is in fact the second Constitution. We need to remember that as well. And as that Constitution is being drafted, the part that we remember most probably now is "we the people," which alludes to popular sovereignty, but another important part of it in the preamble talks about a more perfect union. And when I'm doing lectures or presentations on the Constitution, I always point that out. How many constitutions of a country do you know that begin with the principle, we made a mistake, we admit we made a mistake, and therefore we're going to try and be more perfect. That's our job. But we don't ever say we're perfect, but we're trying to be more perfect. When you look at the Constitution as a legal document, and that's how I would distinguish it from the Declaration of Independence, some people, I think, can get a little confused, including well-known historians who have written that the Declaration of Independence is part of our fundamental law. I would disagree, certainly being trained as a lawyer. Fundamental law is the highest law, but it has to be a law, meaning there has to be a mechanism for enforcement. Within our Constitution, there are 7 parts or articles, and they set up, the 3 branches of government. They govern relationships between the states, set up an amendment process, which I think is really the secret sauce, and also talk about full faith and credit with the states, and set up a ratification process, which does not have to be unanimous. Unlike under the Articles of Confederation, any proposed amendment had to be unanimous. So then the question becomes, and I'll answer this in just a minute, if the Articles of Confederation had to be unanimous, then how can you have a constitution that sets up, well, we only need 9 of the 13 states to start? And maybe I'll go ahead and answer that question right now. All right, let's just stop it there right at that minute. The reason that it was in accord with the Articles of Confederation, remember, this was kind of like a blue ribbon commission, essentially. They met in secret during a hot Philadelphia summer. And the secrecy was enforced when it was finally signed in September of 1787. What happened? You know, we talk about the miracle from Philadelphia. Well, it's not like unanimity suddenly descended on 13 warring brother or conflicting brothers and sisters. What happened was the report from the commission went back to Congress, the Confederation Congress, and they could have shelved it. How many blue ribbon commission reports have been shelved? But they didn't. They voted unanimously not to approve the Constitution, but to summon or call for the ratifying conventions. And they didn't have to do that. So when people talk about the Constitution being a coup, I say, wait a minute, it was still done in line with the Confederation Congress. And then, of course, the ratifying conventions, which the Constitution was ratified in 1788, the new government established in 1789. Let's go to the next slide now. And here's what George Washington says. Remember, Washington's the most influential American at this point, a victorious war general who had resigned his commission, had been called out of retirement to come be in the Constitutional Convention. And then he was in this delicate position as the head of the Virginia delegation, as well as the convention. How vociferous is he going to be in recommending the Constitution? Here's what he said. I wish the Constitution which is offered had been made more perfect, but I sincerely believe it is the best that could be obtained at this time, and a constitutional door is open for amendment hereafter. So going back to the critics, okay, you don't like part of it, you can amend it under the new government. Let's go to the next slide. So North Carolina and Rhode Island take Washington as his word. They're going to wait, actually, until the new government is set up. You know, we have New Hampshire being the key state, the key ninth state for official ratification. But you still have Virginia and New York who are kind of debating after that official ratification. It's with those two that I think the implementation of the Constitution becomes more likely, and it does go into effect. But remember, even once the new government is established in 1789, New York and Virginia are already debating calling a second constitution. And one of the reasons, let's go to the next slide, one of the reasons they're saying that is because they want the Bill of Rights. And of course, here's my favorite founder, James Madison. I love that bust of him at Mount Vernon. I call that the sexy Madison because I think it's just such a good portrait of him. Part of why I respect him so much is he's both a philosopher and a politician. He knows how to take ideas and get them politically enacted. We know he's the architect of the Constitution because he helped develop the Virginia Plan and was the workhorse, really, of the Constitutional Convention. He's the editor of the Bill of Rights because by the time the first Congress is established and he's proposing suggested amendments, all of the state ratifying conventions, just about all of them, have submitted proposed amendments. So Madison, being a very practical politician, just kind of cuts and pastes what he thinks should go into the new Constitution. And it's a proceeding that really he talks about as a nauseous project in a letter to a friend. So you can imagine, how legislation is made. You don't necessarily want to see how it or sausages are made. We think maybe the Bill of Rights, well, that should be a little bit cleaner process, but it wasn't. And Madison was often ridiculed by his own Federalist colleagues. Let's go to the next slide. And this is my wonderful little slide. Congress didn't have an official journal at this time, so independent contractors would get, they would sell subscriptions to the proceedings in Congress. And this was a gentleman named Thomas Lloyd, who was one of those contractors. He was known for having a drinking problem. So when you're trying to document exactly what the debates and references are on the Bill of Rights, that's one of your sources. Let's go to the next slide. So here we have the final Bill of Rights. As you know, it had 12 amendments, not 10. And so when you hear your colleagues in the publishing industry and newspapers say, well, freedom of speech was so important that the framers put it first. And it's like, no, the framers didn't put it first. They put it third. Doesn't have quite the same ring to it, does it? Third Amendment rights. Anyway, it was the people in the states ratifying that only ratified those subsequent 10, and starting with what was the third. And then one of those amendments was later ratified in 1992. Let's go to the next slide. I'm looking at my time. Well, here we have the 14th Amendment. That is the huge change in terms of the Constitution subsequent to the Civil War. It becomes a condition by which Confederate states have to ratify to rejoin the Union. But some politicians today are saying that it's not valid because of that very reason. And just before you exclude it as being totally out of hand, just remember some other arguments that are, including that women should not have the right to vote, that are prominent today. Let's go to the next slide. And my favorite metaphor, where Ken Burns talking about the 14th Amendment is like the Grand Canyon in the middle of the Constitution. This is something that alludes to its scope. Next slide. So what does it do? The most important thing was two things, but most important, it defines citizenship after the Dred Scott decision, in which an enslaved man usually would have been free, considered free under the law when he went into free territory. The Supreme Court ruled that no Black person, free or slave, could ever be a citizen of the United States, even though it's at that time, citizenship was determined by states. And as the dissent points out, in both New Jersey and North Carolina, both free people of color and women who own property were considered citizens and could vote. They changed that quickly thereafter. The second big scope of the 14th Amendment is that it takes the Bill of Rights, which had previously only applied to the federal government, and says this applies to the states too. So it's holding state governments accountable for violations of civil rights. There's also a question that's become more controversial now about whether unlisted rights such as marriage, contraception, or abortion are protected. The Supreme Court's rolling back on those protections. And then finally, it introduces the idea of unreasonable discrimination. Let's go to the next slide. And here we have today's court, which yesterday held that indeed the 14th Amendment does mean that all persons born or naturalized within the jurisdiction of the United States, and that phrase is in fact not meaning what your allegiance or domicile is. That's been upheld. Let's go back to it switched off for a second. The originalism arguments that the current court upholds is stating that what that really does is protect the Americans from having judges' personal opinions enforced in the law, or personal beliefs. Whereas more modern people say you have to look at a full context, not just what was meant in 1868 or 1787. Next slide. And then this is the article. This is my eureka moment when I was in Harvard Law School, and what do I want to do with my life? And here's the answer. Liberty lies in the hearts of men and women. When it dies there, no constitution, no law, no court can save it. This was said during 1944. The picture on the left, most people assume that is Nazi Germany. That is in fact Connecticut, because that was the way that the Pledge of Allegiance was said at the time. And it was because of Jehovah's Witnesses, who were very unpopular, who kept their cases before the court, that was changed. So here's what Hand says, that essentially, yes, we've got constitutions and laws and courts, just like Nazi Germany had, but fundamentally, liberty rests on the actions of everyday citizens. And that's what I believe. Thank you.
Thank you so much, Linda. And we just have a few minutes for some very quick questions. One question, let's jump back to the Treaty of Paris for a second. Can we talk about the absence of Native Americans in the treaty? Especially important because the British they protected their allies in the Black loyalists who left their enslavers to fight for them, and yet they had many Native allies, and it seems like they completely forgot about those people.
Yeah. So, I mean, two things on that. First off, the precedent for not mentioning Native Americans was set in the 1763 Treaty of Paris that ended the 7 Years' War. And that map I put up by John Mitchell, that was drawn when a treaty before that in 1713 was in effect. That did mention Native Americans. So Mitchell's map, which they used at Paris, was full of Indian polities. The Haudenosaunee Confederacy is all over that map. So they're very well aware that Native Americans are there. I think the assumption was that there would be treaties negotiated with an indigenous people after the treaty was negotiated. And the real betrayal in many ways was by Native Americans who went to negotiate those treaties, and they are informed that they are conquered. And the guy who drives the bus on that, if you will, is a Virginian named Arthur Lee at the Treaty of Fort Stanwix. Washington, interestingly, doesn't think this is the right way to conduct Indian diplomacy. And eventually the United States backs off that. But yes, Native Americans are not mentioned. I think it's more complicated than we sometimes think, partly because that had been put in place 20 years earlier in a previous treaty, but it still ends up being a great betrayal.
And I'll just ask each of you to kind of comment on this to wrap this up. It's ironic, it's interesting for anyone who knows Virginia history that the three issues that keep coming up across all these things are land, how far the boundaries of the new America, debt, of course, it's huge amounts of debt for Virginians, and enslaved people. So each of you, just give me your thoughts, maybe Linda, since you didn't have a chance to answer anything, especially the question of slavery and the Constitution. Let's talk about how the Constitution did or did not deal with that.
Well, thank you for bringing that up. I certainly didn't mean to omit that. But one of the great questions was, how do you count population for political purposes? And in the Virginia plan, it said count all free people. So, but really, it's Georgia and South Carolina who are become tremendous populations of enslaved people that push for that. And then the dilemma is, well, if you count all enslaved people in the population, just like you would other people who don't have the vote, children, women, Native Americans, etc., who are you really giving power to? You're giving it power to the people who actually keep those people enslaved. So when we look at the 3/5 compromise, on one hand, which says that we're going to count population 3/5, that's for representation, but also for taxation. So you have a dilemma about, well, if you don't count enslaved people at all, then you don't count them for taxation. If you do count them as a whole person, which modern viewers would say, oh, yes, of course, you want to count people as whole people. But for political purposes, that gives more power to the enslavers.
Well, my dog is getting the last word apparently because somebody knocked on the door. Well, that is about all the time we have for today. Thank you, everyone, for joining us. Thank you for everyone who tuned in. If you found today's event valuable, please consider becoming a supporter of Encyclopedia Virginia so we can keep doing events like this at a time of decreased support for the humanities from the federal government. This is our last series of this for this session. We will have some new entry points in the fall. So thank you, everyone, for joining us, and we will see you next time. Bye-bye.
Oh, I'm supposed to leave, I guess.